Good morning. The committee will come to order. Drew, please call the roll.
Senator O'Loughlin,
Here.
Senator Rowden, Senator Brown, Senator Eigel,
Here.
Senator Luetkemeyer, Senator May,
Here.
Senator Williams.
Present.
Quorum's present.
Hold on, I'm turning this off because. All right, this morning we are going to hear Senate Concurrent Resolution 23 by Senator Schroer. Proceed.
Thank you, Madam Chair. Members of the committee, for the record, State Senator Nick Schroer from the 2nd Senatorial District, presenting Senate Concurrent Resolution 23. This was action taken by the Joint Committee on Administrative Rules, which I chair back on May 25th of last year. Proposed amendment on 5 CSR 20-100.230, rules attempting to implement House Bill 1552. JCAR took action pursuant to Section 536.028.5. The intent of the bill related to full-time enrollment, which was 1552, full-time enrollment for the Missouri Course Access and Virtual Schools program. No longer needed to invoice residents monthly on a pro rata basis, but now could receive full-time payment. Nothing in the law, if memory serves correctly, looking back at these minutes, nothing in the law indicated that payment was to be upon completion, but instead should have been upon attendance, bringing funding below the state adequacy targets. Looking at the statute 536.028.5, we took action due to the fact that this was absent of statutory authority. It conflicted with state law. The rule exceeded the purpose and intent of the law, and it was so arbitrary and capricious as to create substantial inequity as to be unreasonably burdensome on the persons affected. I believe we're going to have some of those individuals here today. But ultimately, this rule also conflicted with federal law, and this concurrent resolution would have to be passed in the House and in the Senate within, I think, the first 30 days, legislative days, for this to be finalized. So with that, I'd be happy to take any questions.
Thank you. Are there any questions from anyone? Senator May.
Yes, you said it so fast. I'm trying to figure out what it is in English.
So we passed a bill 2023 on course access. The rule, when it came through, there were some issues.
Course access, course.
The virtual schools.
Oh, the virtual schools, okay.
And dealing with the payment, the way that the rule was set up, the JCAR committee believed and took action on it, saying that it was so arbitrary and capricious. How it was, the fee schedule, the payment schedule, extended the intent and the purpose of the law. So we're trying to finalize that, go back to the drawing board, and implement something that's consistent with the law and doesn't conflict with federal law as well.
And so the fees are coming from the schools themselves.
Yes, I believe, and I'd have to look back at the bill, I believe it's actually the schools, the way 1552 was set up, the districts themselves would be paying it. And it was very clear when you look at the language of 1552, there's nothing about payment upon completion. And previously it was paid on a month-to-month basis. Mm-hmm. And the way that the rule was set up was conflicting with the clear language of the bill, and conflicted with the purpose of the bill as well from all the different hearings and testimony that we had on virtual schools and course access.
Very good. Thank you so much for
Thank
that
you.
English version.
Any other questions? Seeing none, do we have someone here to testify in favor?
Thank you. My name is Lowell Pearson. I'm with the Hush Blackwell Law Firm, and I'm here on behalf of Stride Learning. Stride is a national provider of virtual services to educational facilities and school districts, and they work with 2 school districts in the state of Missouri. I have some written materials. Would it be appropriate to ask the clerk to distribute those? Thank you. Thank you. Those materials are the letter that I wrote to the Joint Committee on Administrative Rules when they considered the DESI rule at issue. So 2 things I want to talk about with the committee today. First, just to make sure everyone understands what the Joint Committee on Administrative Rules does and did here, and then I'm going to turn quickly to talk about the problems with the rule that was put into place. So the Joint Committee has specific jurisdiction that's narrow but important. And there are 2 statutes that define the jurisdiction of the Joint Committee. And in general, the Joint Committee has the job of reviewing rules to determine if they follow state law and if they're arbitrary and capricious. Those are the two standards that I think are at issue here. So Senator Schroer talked about the legislation that was enacted in, I think it was 2022, and this rule was designed or purported to implement that statute. And the real issue here is a distinction between students who are in a virtual program on a full-time basis versus a part-time basis. And that makes a really big difference here. So there was an existing law that says that if a student is enrolled in a virtual class, in other words, part-time, they could be, the school district would be reimbursed at 94% of the funding formula. And I think everybody agrees, including the department, and Stride does, that for those part-time students, that's not the issue. But in this legislation in 2022, there was a change in the law as to full-time virtual students. Senator Schroer alluded to one of the changes, which is that the payment is made not upon completion of the course, but attendance. And that makes a really big difference, because the payment, if you have to wait to see if completion of the course has occurred, the payment's not made on this monthly basis that Senator Schroer talked about. So that's a significant funding problem for the school districts that Stride works with. And then the other issue is the amount of the payment. As I said a moment ago, existing law, unaffected by 1552, passed in 2022, applied a 94% ratio to part-time students. But what this rule does, and what DESE has done in further conversations we've had with them since May 25th, when the Joint Committee met, has insisted that the 94% ratio applies to full-time students. And it's set out in the letter, but it's quite clear that under the plain language of 1552, which says that the school districts get no less than the state adequacy times the weighted daily attendance of the full-time students. So that language is a little complicated, but what it means in English is they get much more than 94% because those students attend at a much greater rate than 94%. So this is real money, and I'm told several $1 million to school districts, which we believe it's quite clear that they're entitled to under the 2022 legislation. The rule does not implement that legislation as it should. As I said, my client has had a number of conversations with DESE since May, but we're still here. Just the second issue I want to talk about briefly is there was a significant issue with the fiscal note on the rule. The private cost and public cost numbers were less than $500, which I think people on this committee know is code for zero. But that can't be true, because as I just said, the school districts are losing substantial amounts of money under the DESE's interpretation of the 2022 legislation. So, and that's raised in our letter as well. So finally, I would just ask this committee to recommend that the joint resolution pass, send it to the House, or send it to the full Senate. The Senator Schroer is correct about the procedure. Within 30 legislative days of the commencement of the session, both houses have to essentially adopt the resolution, which disapproves the rule, and then that goes to the governor for his consideration. So I appreciate the time and happy to take any questions. Thank you to the members of the committee.
Senator May.
What happens if it don't happen in that time frame?
Well, then the rule goes forward and is in place.
Very good.
Any other questions? Seeing none, thank you for your testimony. Anyone else in favor? Anyone opposed? Anyone here for information only?
Good morning, Committee. Kerry Monses, Deputy Commissioner for the Department of Elementary and Secondary Education. And obviously, this is a very complex and complicated issue. I want to touch a little bit about each one of those areas that were described by the previous presenter and give you the department's position on that, just so you have our context of that and for information purposes for you to make your decisions on. And the language, I'll start with the funding piece for these full-time virtual provider courses. Now, keep in mind, these providers are paired up with a local school district. The local school district becomes the host district, and we are paying that local school district. And I want to be clear, the first semester last school year, we were slow to get our system reprogrammed to make those payments on a monthly basis. But we are making those payments on a monthly basis and have been now for a full year. So I want to make that clear. The language that was cited to you means very different things to the department, and I'll read that one more time. In the case of a host school district enrolling one or more full-time virtual students, such enrolling school district shall receive no less under the state aid calculation for each student than an amount equal to the state adequacy target multiplied by the weighted average daily attendance of such full-time students. The House Bill 1552 did not change or provide a different definition for weighted average daily attendance. That definition exists in previous virtual statutes. And so in our case, we didn't even include language about the funding mechanism in the rule because it was plain language in the statute. So the rule itself does not contain language about the funding mechanism because in our mind, that's a fairly clear definition of how we're to calculate that. And it is using 94%. We are not waiting on full course completion to do that. With weighted average daily attendance, districts are allowed to estimate that, and then we true it up at the end of the year or in the subsequent year. So we are making payments at that 94% rate based on estimates that the host district is giving us. So that's the first one. The FERPA concern, there is some language that we could adjust to make it more clear in the future, but we do not believe that there is any violations of federal statute under Family Educational Rights and Protection Act. So it's just a different opinion, but we think we could strengthen that. And then finally, the fiscal note concern, and this is where probably the attorneys in the room probably have a better sense of this than we do. Our response on the fiscal note was based on the fact that the requirements of cost changes to the statute come from the statute itself. The changes that were made to the rule, and we had an existing rule, were not ones that created the costs that weren't already created by the statute. So the statute included our fiscal note impact of the statute when it went through the rulemaking or the statutory process with your body. The rule itself didn't add any additional costs in our mind, or no substantial additional costs. And we had input from all the providers in that process as we put together the fiscal note for the rule. So I just wanted to kind of share that context as well. And I don't know that I could tell you for sure how to discern whether the costs related to the statute itself should be in play for the rulemaking process. For our interpretation, it was what did the rule cause, not what did the statute itself cause in terms of additional cost. So with that, I'll try to answer any questions.
All right, thank you. Are there any questions, Senator May?
Yes. So basically, isn't this how we fund students who are in attendance with the weighted average? Is that the exact same definition as we fund a student who's coming to the school for attendance?
The only difference here is the student that comes for attendance, we actually count the hours they're present and whatever that translates to in terms of percentage of the entire calendar for the year. If they come 90% of the time, they get 90% of the funding. If they come 100% of the time, they get 100% of the funding. Within the existing virtual statutes, it's been defined as it's 94% is the assumed rate of attendance. And I think it was based on the fact that at the time the virtual statute was written, that was kind of the average for seated students across the state, was about 94%. So that, I think, is the underlying rationale for the 94%. There is a carve-out for A-plus students to be considered at 95% because that's the threshold for A-plus eligibility. But otherwise, we're applying that same process here. And the way we read weighted average daily attendance, we would follow those existing statutory provisions that would account for that.
Okay, very good. Thank you.
Any other questions of the witness? Seeing none, thank you for your testimony. Anyone else for information only? Seeing none, I make a motion, we go into executive session. All those in favor of going into executive session, say aye. Aye. Opposed? We're now in executive session. I now move, excuse me, I now move that the Senate concurrent resolution come before the committee. The Senate concurrent resolution is now before the committee. I move that it be approved.
I have some discussion.
Oh,
After this discussion.
okay, well, is there any discussion? Senator May?
Yeah, so we're going to vote it out today without, is that because we feel that's an urgency, or, because I would definitely love to dive a little bit deeper into what, was just presented. And it's not like it's a cookie cutter presentation. It's going to take some understanding and absorption of that.
Pardon?
I'm good with voting no.
Okay. So you might just need to vote no if you don't feel comfortable.
I am. Thank you.
Senator Williams?
Yeah, and I'll just get with the bill sponsor and discussing.
Work it out.
concerns I have, but, we gonna move forward.
Okay.
When does the 30-day period expire again? If we don't take action on the resolution? When is the?
30 legislative.
Oh, okay. And so what's the deadline date? It's-
We're on the 14th or 15th legislative day so far.
To be all the way through the House.
So we got 15.
Oh,
It's got to not just pass here, but be all the way through the House.
thus the urgency. Thus the urgency. Thank you.
Any other
Thank you, Drew.
discussion?
Somewhat less than 2 weeks.
And my thing, so so we got this, and we're just trusting that we have to do this change based on the conflict and based on the, that it,
Well,
conflicts with federal
Senator
law.
Schroer is the chair of the JCAR committee, so I think that they, did vet it pretty thoroughly and have discussed it, and it's kind of been, I think, an issue sort of hanging for quite a while now.
Madam Chair, you want me to trust Senator Short? No, I'm
Yes.
I'm kidding.
So the resolution is now before us. Drew, call the roll. Seeing no further discussion, Drew, please call the roll. Or hearing no further discussion.
Senator O'Laughlin.
Aye.
Senator Rowden left his vote with the chair as an aye. Senator Brown.
Aye.
Senator Eigel. Senator Luetzemeyer. Senator May.
No.
Senator Williams. By your vote. 5-2, motion do pass.
By a vote of 5-2, the motion does pass. I ask for a motion to adjourn. All those in favor say aye. Aye. We are adjourned.